Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. The continuing court action between Ripple and the United States Securities and Exchange Commission, SEC, has taken a new turn, with greater activity centered on the sealed papers considered critical in reaching a final decision. In particular, defense attorney James Fallon announced in a tweet on February 16 that media personality and Forbes senior writer Rosalind Layton had filed a request to acquire access to the highly guarded Hyman speech paper. Rosalind's petition argued that the press and public have a basic and compelling presumption of access to court materials, as guaranteed by both the First Amendment and federal common law. According to the petition, exercising this right is required to hold the court responsible. Additionally, Layton charges the SEC of inconsistencies in crypto regulation, stating that the agency has yet to provide clear standards for the sector's laws. That enormous significance has translated into intense public scrutiny of Hyman's speech, which, given the SEC's refusal to provide explicit regulatory guidance on cryptocurrencies, constitutes the only instruction anyone within the SEC has offered crypto stakeholders to avoid being on the wrong. End of an enforcement action, writes Layton. Carl Cesare, the proprietor of Cesare EPC, a legal firm focused to Supreme Court and appellate work, likewise confirmed the move. We recently filed this application for permission to intervene in the SEC's Ripple lawsuit, in which the SEC wants billions of dollars in fines from Ripple based on their cryptocurrency XRP, which the agency argues is an unregistered securities, Cesare said. Incidentally, Layton's Forbes piece, which presented a critical analysis of the SEC's alleged unjust handling of Ripple, was mysteriously pulled from the internet seconds after the petition was filed. The Hyman speech, given in June 2018 by William Hyman, then director of the SEC's Division of Corporate Finance, is a key document in the Ripple case, since it is thought to include the regulator's opinion on the categorization of cryptocurrencies as securities. During the hearing, Ripple attorneys have urged the court to require the SEC to provide the records for inspection. The business thinks that the conclusions made in Hyman's speech, which classified Bitcoin, BC, and Ethereum, EEF, as non-securities, might be applied to XRP as well. Public access would therefore be critical in allowing the public to judge the strength of Ripple's fair notice defense. Because if insiders inside the SEC couldn't comprehend the speech's direction, individuals outside the agency couldn't expect to understand it, Layton noted. Importantly, the SEC has charged Ripple with making unregistered securities offerings by selling XRP tokens. It's worth mentioning that some legal experts have questioned the SEC's categorization of securities, leading to debate about the possible conclusion. In this regard, XRP holders' lawyer John Deaton believes that the agency may lose the summary judgment due to uncertainty in securities categorization. Deaton claimed that the contents of the records will ultimately be made public in response to Layton's new petition. It's also an illustration of what I meant when I indicated the Hyman emails would not lead to settlement BC. They ultimately will be made public. I can't put Genie back in the bottle, he said. As all parties await the final judgment, the SEC has filed applications to seal additional documents pertaining to expert witnesses. The action has been criticized by cryptocurrency players, with Ripple responding with an alternative motion. Ripple's A22, David Schwartz, has become a Twitter star. In a tweet yesterday, the Ripple executive and XRP ledger creator made a comment about peeing in a pool, provoking the backlash. I was assured that as long as nobody is particularly close to you in a pool full of people, nobody would know that you did, Schwartz writes. I realize now that this only applies if you're in the pool. The crypto and XRP communities have reacted in force to the amusing tweet. A few Twitter users thought that the Ripple executive's comments may have some hidden meaning. As a consequence, efforts have been made to create ties to liquidity sources. Unfortunately, no such evident relationships seem to exist. It should be noted that, as previously stated, XRP ledger developers are now testing a native automated market maker, AM. Schwartz believes that the AM's qualities, such as the ability to provide single-side liquidity supply, distinguish it from other comparable products. Those who thought the joke amusing but could not see any deeper meaning uploaded tales and memes in response. Nonetheless, the tweet has received appreciation from an unexpected source, Cardano developer Charles Hoskinson. It's also worth noting that Hoskinson's relationship with the XRP community is strained. Notably, he has previously clashed with the community over statements he made about the alleged Ripple settlement date and comments he made concerning the relationship between officials at the U.S. Securities and Exchange Commission and Ethereum. Hoskinson said in December that he would no longer be making remarks on the matter due to the toxic and petty attitude of the XRP community. Furthermore, he said that he had no qualms about terminating relations with the community since XRP had no technical or financial value. Ripple to David Schwartz and Bitcoin supporter Demester recently had a Twitter dispute over whether Ethereum, ETH, was preferable than Microsoft. Miss Thief's shares. Demester initiated the debate with a tweet on the Howey test, a legal criteria for establishing whether or not an investment is a security. Demester stated that ETH meets the Howey test because it is a pooled investment in which the profits are dependent on the efforts of others. "I'm not sure I understand what you're saying," Schwartz remarked. "You assert that ETH represents a joint financial investment in a joint venture. They acquired their ETH directly from ETH, you say?" Maybe not what Brad Garlinghouse had in mind when he joined Ripple Labs as C-Shu in 2015 is to become a pivotal character in one of the largest legal disputes in the history of Bitcoin. Garlinghouse has extensive business experience and is no stranger to tussling with authorities. Hutchinson, Kansas, is where Brad Garlinghouse spent his formative years. Garlinghouse cites his childhood in a tiny town in the Midwest of the United States, where he learned the importance of family and community. Garlinghouse, a college student who was eager to build his resume, interned at various prestigious companies throughout his time at university. Garlinghouse started his successful financial career as an analyst at J.P. Morgan after earning his MBA from Harvard Business School. At this time, Garlinghouse was exposed to some of the most influential people and organizations in the business world, including those on Wall Street and at the World Economic Forum. Despite his many contributions to Yahoo, Tim Garlinghouse will always be known for writing the Peanut Butter Manifesto. This now famous internal Yahoo document critiqued the company's methods and called for more productivity. Everyone in the financial technology sector read the memo. Prior to entering the blockchain and digital asset industries, Brad Garlinghouse worked as an investor with Silver Lake Partners. To fulfill his role as managing director, Garlinghouse researched companies including Dell MC, Airbnb, and Alibaba Group for possible investment. It was at this time that Garlinghouse served as a senior executive at Hightail in addition to his other responsibilities there. By renaming Ascended to Hightail, Garlinghouse made sure the firm kept its promise to serve its global client with innovative productivity solutions. Hundreds of financial institutions across the globe already utilize the Ripple network to make instantaneous international money transfers. Throughout this period, XRP has surpassed other altcoins like Ethereum and Cardano in market capitalization, making it one of the biggest cryptocurrencies on the blockchain. Garlinghouse has often discussed the present state of banking rules and cybersecurity challenges, highlighting blockchain as a possible solution. Because of his outspoken views, the SEC now considers him a potential target in their continuing battle against cryptocurrency. The SEC's complaint against Ripple Labs casts a pall on the CEO's tenure as head of the blockchain company. The action seeks to clarify the SEC's position on the status of the XRP cryptocurrency. According to the SEC, the XRP coin is a security, although Brad Garlinghouse and Ripple Labs see it as a money. Damage to Ripple Labs and XRP from the litigation has been extensive, with the currency being delisted from major trading platforms like Coinbase. Fear, uncertainty, and doubt have clouded XRP's future, reducing its trading liquidity and preventing it from reaping the full benefits of previous bull markets in the first part of 2020. 3. We should get a definitive verdict on this matter. The SEC isn't stopping there with its onslaught on the blockchain and cryptocurrency sector. Kraken was fined $30 million by the SEC in February 2023 because of issues with their staking offering